Morning, Harry. Are you going to visit your dad, Harry? Harry, are you going to go and see the King? Are you going to speak to your dad?
There he is. I'm going to shout, I'm sorry. Sorry, apologies in advance.
Morning, Harry. Are you going to visit your dad, Harry? Harry, are you going to go and see the King? Are you going to speak to your dad?
There he is. I'm going to shout, I'm sorry. Sorry, apologies in advance.
Morning, Harry. Are you going to visit your dad, Harry? Harry, are you going to go and see the King? Are you going to speak to your dad?
There he is. I'm going to shout, I'm sorry. Sorry, apologies in advance.
Morning, Harry. Are you going to visit your dad, Harry? Harry, are you going to go and see the King? Are you going to speak to your dad?
There he is. I'm going to shout, I'm sorry. Sorry, apologies in advance.
Morning, Harry. Are you going to visit your dad, Harry? Harry, are you going to go and see the King? Are you going to speak to your dad?
There he is. I'm going to shout, I'm sorry. Sorry, apologies in advance.
Morning, Harry. Are you going to visit your dad, Harry? Harry, are you going to go and see the King? Are you going to speak to your dad?
There he is. I'm going to shout, I'm sorry. Sorry, apologies in advance.
Morning, Harry. Are you going to visit your dad, Harry? Harry, are you going to go and see the King? Are you going to speak to your dad?
There he is. I'm going to shout, I'm sorry. Sorry, apologies in advance.
Morning, Harry. Are you going to visit your dad, Harry? Harry, are you going to go and see the King? Are you going to speak to your dad?
There he is. I'm going to shout, I'm sorry. Sorry, apologies in advance.
Morning, Harry. Are you going to visit your dad, Harry? Harry, are you going to go and see the King? Are you going to speak to your dad?
There he is. apologies in advance.
Morning, Harry. Are you going to visit your dad, Harry? Harry, are you going to go and see the king? Are you going to speak to your dad?
There it is. I'm going to shout, I'm sorry. Sorry, apologies in advance.
Morning, Harry. Are you going to visit your dad, Harry? Harry, are you going to go and see the king? Are you going to speak to your dad?
There it is. I'm going to shout, I'm sorry. Sorry, apologies in advance.
Morning, Harry. Are you going to visit your dad, Harry? Harry, are you going to go and see the king? Are you going to speak to your dad?
There it is. I'm going to shout, I'm sorry. Sorry, apologies in advance.
Morning, Harry. Are you going to visit your dad, Harry? Harry, are you going to go and see the king? Are you going to speak to your dad?
There it is. I'm going to shout, I'm sorry. Sorry, apologies in advance.
Morning, Harry. Are you going to visit your dad, Harry? Harry, are you going to go and see the king? Are you going to speak to your dad?
There it is. I'm going to shout, I'm sorry. Sorry, apologies in advance.
Morning, Harry. Are you going to visit your dad, Harry? Harry, are you going to go and see the king? Are you going to speak to your dad?
There it is. I'm going to shout, I'm sorry. Sorry, apologies in advance.
Morning, Harry. Are you going to visit your dad, Harry? Harry, are you going to go and see the king? Are you going to speak to your dad?
There it is. I'm going to shout, I'm sorry. Sorry, apologies in advance.
Morning, Harry. Are you going to visit your dad, Harry? Harry, are you going to go and see the king? Are you going to speak to your dad?
There it is. I'm going to shout, I'm sorry. Sorry, apologies in advance.
Morning, Harry. Are you going to visit your dad, Harry? Harry, are you going to go and see the king? Are you going to speak to your dad?
There it is. Sorry, apologies in advance.
Morning, Harry. Are you going to visit your dad, Harry? Harry, are you going to go and see the king? Are you going to speak to your dad?
Yes. Shout, I'm sorry. Sorry, apologies in advance.
Morning, Harry. Are you going to visit your dad, Harry? Harry, are you going to go and see the king? Are you going to speak to your dad?
Yes. Shout, I'm sorry. Sorry, apologies in advance.
Morning, Harry. Are you going to visit your dad, Harry? Harry, are you going to go and see the king? Are you going to speak to your dad?
Yes. Shout, I'm sorry. Sorry, apologies in advance.
Morning, Harry. Are you going to visit your dad, Harry? Harry, are you going to go and see the king? Are you going to speak to your dad?
Yes. Shout, I'm sorry. Sorry, apologies in advance.
Morning, Harry. Are you going to visit your dad, Harry? Harry, are you going to go and see the king? Are you going to speak to your dad?
Yes. Shout, I'm sorry. Sorry, apologies in advance.
Morning, Harry. Are you going to visit your dad, Harry? Harry, are you going to go and see the king? Are you going to speak to your dad?
Yes. Shout, I'm sorry. Sorry, apologies in advance.
Morning, Harry. Are you going to visit your dad, Harry? Harry, are you going to go and see the king? Are you going to speak to your dad?
Yes. Shout, I'm sorry. Sorry, apologies in advance.
Morning, Harry. Are you going to visit your dad, Harry? Harry, are you going to go and see the king? Are you going to speak to your dad?
Yes. Shout, I'm sorry. Sorry, apologies in advance.
Morning, Harry. Are you going to visit your dad, Harry? Harry, are you going to go and see the king? Are you going to speak to your dad?
Yes. this. I'm going to shout, I'm sorry. Sorry, apologies in advance.
Morning, Harry. Are you going to visit your dad, Harry? Harry, are you going to go and see the king? Are you going to speak to your dad?
This. I'm going to shout, I'm sorry. Sorry, apologies in advance.
Morning, Harry. Are you going to visit your dad, Harry? Harry, are you going to go and see the king? Are you going to speak to your dad?
This. I'm going to shout, I'm sorry. Sorry, apologies in advance.
Morning, Harry. Are you going to visit your dad, Harry? Harry, are you going to go and see the king? Are you going to speak to your dad?
This.
Stop the live stream on which there is a delay, and so no harm will be done provided you get your point across within 90 seconds. And then we can decide what to do in the particular circumstances rather than having a particular plan in every case. As far as the court is concerned, we're not really very keen to distinguish between particular levels of confidentiality. We note that in the bundles there are all sorts of levels of confidentiality. I think we'll just have one level of confidentiality, namely confidential and open. We accept, though, that some aspects of the evidence in this case cannot be made public appropriately, and that's why part of the hearing needs to be in private. But that does not detract from the fundamental principle that court hearings in this country are held in public. And we should like to see as much as possible of the legal and factual argument undertaken in open session, with suitable caution being exercised by the advocates to ensure that confidential material is not disclosed. I just wanted to be clear before we start about the importance of the open justice principle.
I'm very grateful, my Lord.
Good.
In terms of the structure of my submissions, I'm going to start first of all with the relevant legal principles and the case law. At the end of that section, I will address the respondent's notice and the points of law raised by it. I'm then going to address the grounds of appeal in the following order. First of all, ground 1A, and then I'm going to take 1B and C together, and then 1D and 2 together. My Lords, before turning to the law, could I make 7 introductory points? The first is to identify some common ground. It is common ground that when RAVEC made its February 2020 decision about the appellant's protective security, it did not apply its own terms of reference to that decision-making process. Those terms of reference say that RAVEC will base its decision-making on an assessment from an expert specialist body called the Risk Management Board, or the RMB as I will call it. It is also common ground that RAVEC did not get an RMB assessment for the appellant. Instead, RAVEC came up with a different and so-called bespoke process which, as that label makes clear, is not applied to anyone else. I will use bespoke, partly because it's shorthand and partly because it was used in the judgment below, but the appellant does not accept that bespoke means better. In fact, in his submission, it means that he has been singled out for different, unjustified, and inferior treatment. Not only does this bespoke process not involve the RMB, it also involves RAVEC considering the reason why the appellant is attending a particular event, even though that is plainly irrelevant to the question of security. This first introductory point is particularly significant because the appellant's case is not that he should automatically be entitled to the same protection as he was previously given when he was a working in the royal family. The appellant's case is that he should be considered under the terms of reference and subject to the same process as any other individual being considered for protective security by RAVEC unless there is a cogent reason to the contrary. Second, it follows from this that the core question raised by this appeal is whether RAVEC has given a clear, logical, and convincing reason for departing from its terms of reference and failing to do an RMB for the appellant. The answer to that question is no. Third, the judge's starting point for that good reason question, as I will call it for shorthand, was that the RMB assessment is optional or discretionary. That is wrong. And that fundamental error of interpretation then completely tainted his analysis on good reason. Contrary to the judge's analysis, the RMB assessment is a key and crucial feature of the RAVEC process. The requirement to undertake the RMB is expressed, as we will see, in clear and unqualified words in the terms of reference. And we know that there are very good reasons for that requirement, and we know it because of what RAVEC's own documents and RAVEC's own witnesses about the distinct expertise of the RMB. Fourth, whilst it is right to acknowledge that RAVEC has expertise in relation to matters of protective security, the nature of the issues raised by this case do not require the court to defer to RAVEC. There is no separation of powers issue here, nothing that is beyond the court's institutional competence. The judge wrongly deferred to RAVEC, and deference is at the heart of the respondent's resistance to this appeal. That is illustrated by RAVEC's contention that the starting point for interpreting the terms of reference is a presumption that RAVEC knows best. That the court should accept RAVEC's understanding of its processes, even when that understanding does not match the words on the page or what RAVEC does in practice for others. That is what the judge did, and he made a mistake when he did so. Fifth, RAVEC also contends by its respondent's notice that the court should not look to see whether RAVEC had a good reason, but that it should apply far less scrutiny and just ask whether RAVEC's decision was unreasonable. The judge rightly rejected this legal submission, but he did make another legal. And that mistake was to ask whether there was a good reason for RAVEC's approach when he should have gone further he should have applied the test of cogency, and he should therefore have intensely scrutinised Ravek's decision by asking whether the reason relied on was clear, logical and convincing. Sixth, had the judge done that, he would have concluded that Ravek's reason for not doing an RMB for the appellant doesn't stack up, especially when one looks at what Ravek has done for other people. The lack of scrutiny led to the judge wrongly accepting Ravek's evidence, and that evidence says that a so-called bespoke process makes much more sense for the appellant than the RMB. My lords, that evidence has not come from the RMB, and it doesn't make sense when one considers in detail the expert analysis that the RMB assessment involves. It is impossible to speculate on whether the appellant would be in the same position had he been given the benefit of the process which Ravek's terms of reference mean and which Ravek has given to others. The final point is that the failure to do an RMB for the appellant means that Ravek did not have the expert analysis that it needed in order to consider whether or not the appellant should be treated similarly to those in the other VIP category, or OVC as I will call it. And Ravek did not make a reasonable decision because the appellant's position is analogous to those in that OVC category. Had the judge properly evaluated the evidence, he would have come to that conclusion. With that introduction, I want to turn to the relevant legal principles and the case law. There are 6 key legal propositions that are relevant on this appeal. The first 2 relate to good reason, the third to deference, the fourth to both good reason and interpretation, and the last 2 to policy interpretation. I'm going to just start, my lords, by identifying those propositions and giving you the references to the authorities in support, and I will then ask you, please.
Maybe one of your juniors could let us have those principles written down if they're not in your skeleton?
Yes, of course, my lord. They are in the skeleton. I'm going to synthesise them in a way which I hope is helpful for the court.
Well, if you're going to synthesise them in a different way from the skeleton, electronically as soon as possible to save our typing it all out.
My lord, yes. I'm sure somebody is doing that.
And take it slowly so that we can understand your new synthesization.
I hope it's not new.
Synthesis, I should say.
I hope it's not new, but let me have a go. My lords, the first proposition is that where a public authority has issued a promise or adopted a practice which represents how it proposes to act in a given area, then the law requires that promise or practice to be honoured by that public authority unless there is a good reason not to do so. And I'm going to refer to this, as the court did below, as the Nadaraja principle. And the most recent key authority in support of that is Hemati at paragraph 69.
Sorry, which one?
Hemati.
Hemati.
Yes. And it's in our skeleton, my lord.
Paragraph 69.
Yes, and our skeleton, paragraph 24, refers to that. And indeed to what I've just said. The second proposition is that the standard of review when considering the claimed good reason is whether the decision maker has shown a cogent or compelling reason which is spelled out clearly, logically and convincingly. And that is Munjaz, paragraphs 21 and 69.
Spelled out what? Sorry, I was a bit behind you.
Clearly, logically and convincingly.
That's Mumtaz.
It's Munjaz 21 and 69. Also Tower Hamlets 35 and Our Skeleton 37.
Which one in Tower Hamlets? Which para?
35, my lord.
Thank you.
And my lord, I'm also going to have a look at the Begum case, which the respondent has relied on as part of that second proposition. The third proposition is that although a court may give weight to or defer to the judgment of a decision maker, the level of weight or deference will depend on the context of the reason of the decision and the evidential value of the particular judgments made by the executive.
Evidential value of the particular judgment
Made by the executive. And that is Carlisle, para 22, Our Skeleton, para 30.
Sorry, Skeleton, Carlisle 32 and Skeleton 30.
Yes. The fourth proposition is that the certainty with which a policy is expressed may be relevant to whether or not there was good reason to depart from the policy, and the greater the departure from the policy, the more compelling the reason must be. Key authorities are HZ, para 107.
Mr. Justice Henshaw.
Yes. And Tower Hamlets again, para 35 again.
Yes.
My lords, just before I go on to the fifth proposition, this fourth proposition that I just described explains why it is so important in this case to start with the correct interpretation of the terms of reference. And as you know, as I've already said, we say that the clear and unqualified terms in which the RMB requirement is expressed, the rationale for that requirement, and the way it has been implemented in practice all mean that the threshold for departing from it is high. And that is something which the judge did not properly appreciate. And that is why I emphasise not just that fourth proposition, but that prior interpretive stage before one comes to good reason. Is the final arbiter of what a policy means. Including its scope.
Including scope.
Including its scope. And the meaning to be given to a policy statement is what a reasonable and literate person's understanding of the document would be. And my lord, the key authorities are again Hemati, para 69, Mandelia, para 31, Raisi, paras 123 to 124. And those are in our skeleton at 24 to 25. The final proposition is that there is no general principle that when the court interprets a policy, it must always start from the presumption that the decision maker's interpretation and understanding of the policy framework is correct.
That's very precise. I mean, just the framework.
That's going to be the proposition.
Okay.
My Lord, the judge was wrong to say otherwise. He relied on Hopkins Homes.
Sorry?
He relied on Hopkins Homes.
Yes, indeed.
And I'll come to obviously go through the judgment, but just for the court's reference, that's in the judgment at 175 to 176. And we say that he was wrong is shown by, again, Hemati para 69, Mandelia para 31, and a short extract from DeSmith, which I hope you've received.
Thank you.
Paras 191 to 192. And again, that's our skeleton 31 to 30. So with that, could I ask the court to please have a look at some of those authorities? Could we start please with Hemati, which is 2021. It's in the authorities bundle 2 and it's tab 21.
Help me if you could give electronic page references.
So 801, I hope, my Lord, will take you to it.
801.
Yes, so when I give the references, I'm going to give you what you should have in your electronic bundle rather than the pagination internal to the report, if that's
Electronic
easiest.
bundles.
Yes.
Very helpful. Yes, thank you. Hemati, yeah.
My Lords, this is the most recent articulation of the Nadaraja principle, and I'm not going to take that case up right of interpretation, and we also rely on it in support of the no Hopkins presumption. If we can just have a quick reminder of the facts and the outcome from the head note. There was detention pursuant to the discretionary power to detain conferred by Schedule 2 to the Immigration Act 1971. You can see that, I hope, at letter F in the margin. The claimants sought to judicially review their detention on the ground that it breached a council regulation. And at first instance, and you can see this at letter G, 4 out of 5 claims were dismissed. Court of Appeal allowed those appeals, dismissed the Home Secretary's appeal. The Home Secretary appealed to the Supreme Court, but that appeal was also dismissed. And if we go over the page to page 802, you can see from letter D that one of the reasons the appeal was dismissed was on the basis that the Home Secretary's policy in relation to detention pending removal in Chapter 55 of the Enforcement Instructions and Guidance did not satisfy the requirements of law within the meaning of that regulation. And if I can ask you please to go to page 831.
I'm just trying to find where it says that. It does not have the necessary qualities of certainty and predictability constitute a binding provision of general application so as to amount to law.
Yes. And if my Lord looks further up,
Yeah.
you can see 3 lines above D.
Above D.
Yes, did not establish objective objective criteria for the assessment of whether such a person might abscond. Contents did not constitute a framework of certain predetermined limits, and so on.
Yeah.
If we could go to page 831 in the judgment of Lord Kitchen, you can see at the bottom of the page the heading Domestic Law.
So Lord Kitchen was the lead judgment?
Yes, he gave the judgment on behalf of the Supreme Court, and my Lord will see that from the top of page 820.
Yes, everybody agreed with him.
So, page 831, para 40 is where the description of domestic law starts, and we can see within that, on page 832, para 43, a description of the policy. So that's chapter 55, which we saw referenced in the headnote. And then if we can just turn on to page 834 and paragraph 50, you can see there that Lord Kitchen says, and he accepts, that the executive must follow the stated policy unless there are good reasons, good grounds for...
Sorry, I'm not with you. Where are you reading?
Paragraph 50, my Lord.
50, yeah.
Page 834.
First sentence, yeah.
Yes, exactly.
Thank you.
So he said that, and then he goes on, and you see this over the next several pages. He analyses and interprets the chapter 55 that we saw of the policy. And that is the analysis that was in the head note as to whether or not it satisfied the criteria and requirements of the regulation.
Is this a type of policy matter? I mean, this is a public-facing, published policy in this case, is it not?
Yes.
Yes. This was not in our case.
No, I'm going to show you an example. Mandelia is an example of a policy that was not published, and in my submission, for the propositions that I have given you, there is no difference. And in particular, I'm showing you this case, as I said.
So just to be clear, your submission is there is no difference. That even in terms of context, the court would not regard a policy of the kind we're dealing with here as different from a published public policy for the public at large, immigrants at large in this case, from something as very narrow as the RAVEC policy as a reference we're concerned with here. I'm just interested to know what you say. I mean,
my Lord,
actually one might have thought that the court would anyway look at the context in which the policy was published, right?
yes, but in my respectful submission, the principle that the court is the final arbiter is not different. That is my point.
Oh no, as to the final arbiter of what it means.
Exactly
Yes,
so, my Lord.
absolutely.
Exactly so.
I'm not sure that's in contention.
Well, except for the Hopkins presumption point.
Okay, well we're going to come to
And we're going to come to that. And as I said, I'm showing you this in part. You will have appreciated that this is a few years after Hopkins Homes.
Yes.
Hopkins Homes was 2017, this is 2021. I'm showing you this in part to show you what the Supreme Court did when faced with a policy that had interpreted it, and I'm going to just show you a few other passages to make good my point that this doesn't support the Hopkins presumption.
Were they asked to consider Hopkins in this case?
No, interestingly they weren't. Nobody even cited it. But could I just return to my Lord's question? I don't want to not answer it fully. So, in terms of the proposition that the court is the final arbiter and the presumption, I do say that this is the same, whether it's outward facing or internal. Mm-hmm. I will come on to look at what matters when you're interpreting as the final arbiters. And in my submission, it will be purpose, content, that is the text, and context. So, of course, when the court is actually engaging in that interpretive analysis, you do look, in my submission, at the context. And that can include outward-facing, internal-facing, and so on. So, my Lord, I was just going through this section, which starts now on page 835. It's the heading just above paragraph 52, to say that you can see from the pages that follow the interpretive exercise that the Supreme Court did. It goes all the way up to paragraph 74, but I wonder if we could just stop off and look at paragraph 69 first of all. Paragraph 69 is the one that I've identified to you as the basis for the propositions I've given you about Hemati. It is on page 100 and 840. If I could just ask you to read that before I make some points about it.
Is that the one that you referred to in relation to 3 or 4 of your propositions?
Yes, my Lord. Yes.
I mean, you can read it out. It always helps me if you read it out. I know that.
Certainly. I'm conscious that my lords may get tired of hearing my voice.
Well,
but
except that it's only 10 lines, and it may be important for everybody else in court
yes.
to hear what you're saying.
There can also be no doubt that in this jurisdiction, a policy statement such as Chapter 55 of the EIG has significant legal effects. I have referred to these at paras 50 to 51 above. In broad terms, and as Lord Justice Laws explained in Nadaraja, where a public authority has issued a promise or adopted a practice which represents how it proposes to act in a given area, the law requires that promise or practice to be honoured, unless there is good reason not to do so. Moreover, the court is the final arbiter of what a policy means. There's then a reference to Kambadzi and Mandelia, which we'll come on to look at. It is also well established that compliance with such a policy is enforceable by individuals before the courts. So, my lords...
So you say that's very clear and comprehensive.
Clear and comprehensive in, first of all, setting out the Nadaraja principle, setting out the court as the final arbiter, but then it's a nil return, if you like, in terms of Hopkins. There's nothing there about a general presumption. And this would be the sort of case to say it, because it's an immigration case. And as we'll come on to see, the respondents say that planning and immigration are examples of where the presumption that they rely upon. So nothing here. And as I said in response to a question earlier, my lords, it wasn't even cited in argument, let alone referred to by the court. The next authority is Mandelia, which is 2015, and it's Bundle 1, Tab 12, and electronically it should be page 475.
This is earlier, isn't it?
I'm so sorry, my lord, I didn't...
Earlier.
Yes, this is 2015. And again, just as a reminder, I'm citing it for court being the final arbiter and also the no Hopkins. Again, if I could just take the facts from the head note on page 475, you can see from the top of that there was an applicant for a UK visa and he failed to provide evidence of sufficient funds for the requisite period. You can see that between letters. He only provided evidence for part of that period. And then we can see going down to G that there was a process instruction given to border agency caseworkers, which required that in certain circumstances they ask further questions from the applicant before determining the application, and no such request was made to the applicant. His application was refused. So pausing there, my Lord, this is an example of that internal-facing policy that I referred to earlier. If we go to page 478.
It was unpublished, the process instruction.
Yes.
Yeah, sorry, which page?
Page 478. This is the judgment of Lord Wilson for the Supreme Court, and you can see the question that the court was considering between letters B and C. The question is, did it act unlawfully in refusing his application without having first invited him to supply a further bank statement and so on?
Okay, I'm not not with you where you are. Which paragraph?
It's the continuation of paragraph 1.
Oh, right, okay.
And it's page 478 between letters
between B and C. Yep, got it. Thank you.
The relevant legal principles start at paragraph 29 on page 484. And you can see from the top of page 485, and again it's between B and C, that Lord Wilson refers to the applicant having the right of his application in accordance with policy. Now generally taken to flow from a principle no doubt related to the doctrine of legitimate expectation but freestanding, which was best articulated by Lord Justice Laws in Nadaraja, and we there have set out that paragraph 68 from Nadaraja.
Yes.
And then the key paragraph that we rely on is 31, which is at the bottom of that page. And if you could have a look between letters G and H, please.
Yes.
Lord Wilson says that the Secretary of State does not say there were good reasons for not following the policy, but that properly interpreted the instruction did not require the caseworker to alert the applicant. And he then says that the search is for the proper interpretation of the process instruction. You see that at the bottom of the page. No more and no less, he says. Indeed, in that regard, it is now clear that its interpretation is a matter of law, which the court must therefore decide for itself. And over the page, previous suggestions that the court should adopt the Secretary of State's own interpretations of her immigration policies unless it is unreasonable, made for example in Gangadeen, are therefore inaccurate. And we say again, my lords, that this paragraph shows that the respondent's reliance on Hopkins as creating a presumption of general applications is not a good one. And just so the court has the answer that was given to that question that we saw in paragraph 1, it is in paragraph 36 on page 487. And you can see that the conclusion reflects the fact that the Supreme Court interpreted the policy for itself and said that the process instruction obliged the caseworker first to have invited Mr. Mandelia to repair the deficit in his evidence. My Lords, this case illustrates the point that procedure may in itself provide a benefit, because the right to file more evidence in this case, in Mandelia, was part of the procedure, but it was also a benefit. And similarly, we say, in the present case before this court, that the need for an RMB assessment is part of RAVEC's procedure, but also a benefit. And that is relevant when we come on to look at the good reason part of the analysis.
Do you think it could be said against you that you're trying to put public law into a very inflexible series of boxes at paragraph 178 and following, declined to do in this case because of the context? And he made that criticism effectively. I mean, the cases you've shown us so far are all immigration cases with policies that apply to, even if not published, apply to hundreds of thousands of people. And a process in immigration does have to be fair. All processes have to be fair, but the processes don't necessarily have to be the same in every type of case, because fairness is not put into little self-contained boxes. And I'm just interested to know whether you would accept the criticism that so far you're adumbrating really quite inflexible, monochromatic rules that are applicable to everything called a policy. And we've, for the avoidance of doubt, looked very carefully at the underlying documents in this case. And the so-called policy is, in fact, called terms of reference.
Yes.
And is quite short and not the same, anyway, as many of the immigration policies many of us have had quite a good opportunity of looking at. What do you say about applying these sort of tightly drawn principles in this situation?
My Lord, I would not accept that criticism if it were to be made. And the reason for that is I don't accept the characterization that what I've described to you are tightly drawn boxes. What I've described are principles or propositions that guide the way the court should approach this particular case, involving, as it does, the interpretation of a policy. I entirely accept that each policy will be different, and what it requires in terms of the court's consideration will be different. And I am going to come on to look at what, on the facts of this case, I accept you should be looking at. Contrary to the characterization in the judgment, I am not pressing on you a mechanistic, literal interpretation. And the reason for that, and obviously I will come on to develop this, is I don't say that we get the meaning from the four corners of the document. I don't say that. That is why this isn't about boxes or tight adumbrations which may be a straitjacket in a public law context. This is to say, and as my Lord said, it is accepted that the court is the final arbiter, subject to the difference on Hopkins. The question is how you go about that job. And in my submission, you don't defer to what RAVEC thinks the policy means or says, but that's one end of the spectrum that the respondents are pressing on you. I'm not going to the other extreme end of the spectrum to say, well, just look at the words on the page. Don't look any further. Look at it as if it was an act of parliament or a contract, although, of course, even in those cases, one doesn't just look at the words on the page. I am going to be inviting you to take a much broader lens, to look at the purpose as well as the content. And when we come to look at the context, I will identify 4 strands that I say are relevant and engaged. And my Lord will see in due course that those 4 strands reflect the world that we're in of protective security provision, which is obviously different from planning or immigration. So, my Lord, I would not accept the criticism for those reasons.
Okay, thank you.
I want to move now to Raisi, which is 2008. And it is Bundle 1, Tab 6. It's page 224 of the electronic bundle. And you can see from the head note, letter G, that the claimant applied for compensation for detention under an ex gratia scheme, which was introduced in a ministerial statement to Parliament. He refused his application. He applied for judicial review. And we can see, if we go over the page, please, a few lines above letter B, that the claim, on the basis that it was for the Home Secretary to decide the meaning and scope of his policy, provided that his interpretation was one which a reasonable minister could reach. And then you can see, if you have a look at a few lines above C, that the correct test in interpreting the ministerial policy statement was to ask what a reasonable and literate man's understanding of it would be, and not whether the meaning attributed by the minister to the words of the policy was a reasonable one. It was for the court to decide what the ex gratia scheme meant on the basis of what a reasonable and literate person would understand the circumstances to be. And could I just give you, for your note, that the statement is at paragraph 4 on page 231, and it makes clear that there was no underlying statutory provision in that case.
Yes.
And then if we can have a look at the two paragraphs which I've cited to you, paragraphs 123 and 124. They are on page 258. And in 123 you can see that the Court of Appeal say we shall use the ex parte web text whilst accepting that it could be worded in a more modern way. That text that they have referred to is in paragraph 108, which is on page 254. And it's in the quotation at the bottom of that page. So if you could pick it up 3 lines from the bottom. The government has made funds available for the payment of compensation without being under a statutory duty to do so. It follows in my judgment that the court should not construe this scheme as if it were a statute, but as a public announcement of what the government was willing to do. This entails the court deciding what would be a reasonable and literate man's understanding of the circumstances in which he could, under the scheme, be paid compensation for personal injury. And then if we go back to page 258, you can see the questions that are posed there in paragraph 124. What does the scheme mean? What was its purpose and scope? Who is the minister intending to compensate? We've already set out its terms at para 4 above. The purpose of the scheme, as set out in para 1, was self-evidently to compensate those who had spent a period in custody resulting from a serious default on the part of a police officer. So that point that is being made there, namely that the terms of the policy define its scope, because that's what the court is doing, it's interpreting who comes within the scope. We see that there, those who had spent a period in custody and so on. Evident from the observations of Lord Steyn in the McFarlane case, which is set out earlier in the judgment on page 256. So if you go to 256 and have a look, please, at letter G. This is the quotation from Lord Steyn, who was dissenting in that case. He says, the decision maker, here a minister, may depart from the policy, but until he has done so, the citizen is entitled to ask in a court of law whether he fairly comes within the language of the publicly announced policy. That question, like all questions of interpretation, is one of law. Now, although he dissented in that case, this dicta has been followed by courts and accepted to be good law. And I just refer, in support of that, to my Lord Justice Bean in the Secretary of State for the Home Department in JB, which is 2022 EWCA Civ 1392 at para 56.
So is that not in the bundle?
No, my Lord, it's just...
Give us the reference again then.
Yes, of course, certainly. It's 2022
Yeah.
EWCA Civ 1392.
Yeah. Can it be provided to us electronically?
Yes, of course, and it's para 56. So that is Raisi, and could we then go to Hopkins Homes, which is 2017?
Sorry, just before you leave that, could you read the bottom to the end of 124? I think you were on page 258.
Well, my Lords, I've already addressed that point. The appellant is not pressing a legalistic interpretation on this court. I've already said I'm going to come back to purpose, content and context. Could we then go, please, to Hopkins Homes, Authorities Bundle 2, tab 16, and it's page 622, electronically. The respondent relies on this for paragraph 22, which is the uncontroversial proposition that a policy is not to be interpreted as a statute or a contract. I've already shown language to that effect. But the respondent also relies, and I will show you this, on paragraph 25. And it is said that that establishes a general principle that, and I quote from their skeleton, the court should respect the expertise of specialist decision makers applying a policy and start at least from the presumption that they will have understood the policy framework correctly. That's para 12 of the respondent's skeleton. And the judge accepted this in the judgment at 175 to 176, and we say that is wrong, and this case is not authority for that proposition that the respondents rely on it for and that the judge accepted. The case involved a planning policy, again just taking the facts from the head note.
Are there an infinite spectrum of decision makers, running from a Home Office official making decisions about hundreds and thousands of immigrants who absolutely require to be able to follow closely the words of a clear policy in order to be fair to everyone, through planning inspectors who are decision makers of great expertise and with long experience in making planning decisions, to whom some deference is obviously, or some respect is obviously due, through to people who make decisions about a very small cohort of people and are no doubt expert in national security.
Yes.
I mean, they're not the same.
No. And it's no part of my case
And it's
to
all
try and
very
say...
much more nuanced.
Absolutely. Absolutely. And I'm at pains to emphasise...
I'm not saying Hopkins is wrong.
No, not at all. I'm saying that I'm saying that the way in which it is relied upon by the respondents is wrong. Because Hopkins is about planning, and the presumption that Lord Carnworth identified that I'm going to show you is about planning, and it's about the specific context of that case. What the respondent says is, no, this isn't just about planning. You can pluck this out of Hopkins, the planning context, and you can plug it in to protective security. So you, the court, are being invited to accept that your starting point, that is the way it is put, your starting point is the presumption that they know their policy. And I say that is wrong in terms of being a general starting point which creates a presumption in every case. So it is the respondent's case that is not allowing for nuance here. They are the ones pressing upon you an absolute presumption. So, my lord, I don't say Hopkins is wrong. I say Hopkins is limited to what it decided. And that is why I say we didn't see it in Hemati, we didn't see it in Mandelia, and that's for the very good reason that they weren't planning cases.
But, I mean, the question of whether it's applicable, in other words, something similar is applicable, is a matter for the court in every case.
Yes, as part of context, absolutely. Yes, and also there is a more general question, and I've addressed you on this, and I will come to show you Carlisle, which is this general notion of deference or weight. And again, it's no part of my case that Ravek does not have expertise. I accepted that in my opening remarks. But my lord, one of the key ironies about this case is that the respondent presses on you Ravek's expertise whilst ignoring the expertise of the RMB. And that is something which I will come back to. What we are saying is your own process says you have to defer to the expert specialist body that your documents explain the importance of.
Let me just say something that may help you to address your submissions effectively later. I shall want to understand why you say that in this case any determination by RMB would have actually affected the way in which Ravek dealt with the issues of the claimant, particularly in circumstances where he was doing what he was doing, because the RMB assessment, as I understand it,
yes,
is obviously it's a very detailed threat assessment, risk assessment, detailed analysis of all sorts of aspects of what's going on in the world. But what I'm slightly concerned about at the moment is, again, putting it into discrete boxes and saying the RMB is relevant to what Ravek was considering about this claimant in these actually unique circumstances.
Yes, and my lords, I will come to deal with, I hope, precisely that point. I do say this, though, given the nature of the submissions, that will be in closed session.
No, well...
So I will come on to that, but it won't be today, is my point. It will be tomorrow.
Yeah, okay.
But I hope that when we go through the documents, I will try and flag, especially in terms of the documents that the court has and is able to see, the parts that will pertain to that.
Will be relevant.
Yes.
Yes, well that would be very helpful. Thank you.
I was just showing you Hopkins and the facts. The context is the planning permission applications, and we can see between letters F and G that in each case the inspector had to establish whether particular policies of the relevant development plans were considered not up to date under the national planning policy framework, and if so, what the consequences for his decision should be. And then if we go over the page to page 623, you can see the finding between E and F. And if I read it out, it's 3 or 4 lines down from E. The court's role was not to be overstated, and courts should respect the expertise of the specialist planning inspectors and start with the presumption that they would have correctly understood the policy framework.
I'm sorry, where are you?
Between E and F, and it's maybe 623.
Yeah, thank you. Sorry.
And it's 3 or 4 lines up from F.
Yeah.
And the bit I read out was the court's role was not to be overstated, and court should respect the expertise of the specialist planning inspectors.
Yes, I see.
And so that's essentially the bit that the respondent relies on. But if I can show you in the judgment, and this is the judgment of Lord Carnwath for the Supreme Court. And if we go first of all, please, to page 633, and you can see, I hope, at the bottom of that page, the law and policy. Paragraph 22 refers to the correct approach to the interpretation of a statutory plan. That's Tesco. That's then set out over the next page, and page 634, para 24. He says, in the first place, it is important that the role of the court is not overstated.
Yes.
And then over the page again to paragraph 20. And this is really the core passage for the respondent. He refers to whether it's a development plan or a non-statutory statement such as the NPPF. They're statements of policy, not statutory texts, must be read in that light. Even where there are disputes over interpretation, they may well not be determinative. Furthermore, the courts should of the specialist planning inspectors and start at least from the presumption that they will have understood the policy framework correctly. That's obviously the bit that I read out from the respondent's skeleton argument that they rely on. And then you can see that he refers to the role and says it's in some way analogous to that of expert tribunals, in respect of which the courts have cautioned against undue intervention there to an immigration judgment. Para 26, recourse to the courts may sometimes be needed to resolve distinct issues of law or to ensure consistency of interpretation. Specialist judges of the planning court have an important role. And then at the end of that paragraph, you can see there that he draws a distinction between issues of interpretation of policy, appropriate for judicial analysis, and issues of judgment in the application of that policy, and not to elide the two. So, as to those two paragraphs, we make 3 points. They're in our skeleton argument at 32, but if I can just summarise. Paragraph 26, as I've just shown you, demonstrates and identifies that critical distinction, we say, between the interpretation of a policy and its application in respect of the former. And we say, secondly, that the analysis and conclusion that I've just shown you throughout that section, starting from paragraph 22, is highly fact and context specific. It is about planning. Self-evidently, we would say. It is.
Of course, the case is about planning. Why isn't the proposition of general application that the courts should respect the expertise of the expert decision maker and start at least from the presumption that they will have understood their own policy framework correctly?
Because, my lord, that's our mission, your role as the arbiter of the interpretation of the policy. You are entitled in my submission to have regard to how the decision maker interprets the policy, but to suggest that that is the starting point, and indeed a presumption that has to be overcome by the other party to the litigation, is in my submission wrong. And we saw that in the earlier cases where they talked about this idea that you start with the fact that the decision maker has applied and show it's not reasonable. So it's not to say that you don't look at their expertise or how they've understood it, but you don't start from the presumption that they are right.